So another federal court ruled on the federal laws which restrict the possession of machine guns under the GCA. AG Bondi and the Trump administration continue to argue against the Second Amendment in these cases, and the Court of Appeals just ruled in their favor. So let's break down what just happened in this critical decision and what happens now going forward. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, AOR is in a league of their own. They're a program that's backed by an actual law firm, the Attorneys for Freedom, and they can help you in self-defense situations that maybe other companies could not. In my opinion, they're one of the best on the marketplace right now, and they offer a ton of things. They actually expanded their benefits recently, so you can get things like civil liability coverage, red flag law coverage, and then expungement coverage, a lot of things that they added into their program. And if you sign up this year, you can lock in your price because next year they're going to be increasing the cost. But if you sign up this year, you lock in that price. So I highly recommend checking them out using my links down below. And if you sign up using my code ARMEDSCHOLAR, you can get $50 off of an individual plan or $25 off of a family plan. As I mentioned in the intro, we recently received a decision out of the 10th Circuit Court of Appeals, which upheld the GCA's machine gun restrictions despite the Second Amendment. This comes after the Trump DOJ continued to argue against the Second Amendment in these cases, and they continued to argue that machine guns could be restricted. Now, you may recall that recently we had two district courts, rule and dismiss machine gun possession charges using the Second Amendment and the Supreme Court's recent 6-3 ruling in Bruin. The most recent ruling came out of the Mississippi District Court, and that was issued by Judge Carlton Reeves in a case called U.S. v. Brown. However, that ruling cited heavily and relied heavily on the case we're going to be talking about in this video, which was ruled on by the 10th Circuit, and that is the U.S. v. Morgan case. In Morgan, a federal judge in Kansas found that machine gun possession charges were unconstitutional in violation of the Second Amendment as they applied to this individual, Mr. Morgan. This Kansas Morgan case and that decision was appealed then to the 10th Circuit, and the U.S. government and the Trump DOJ continued to argue to the 10th Circuit that they could restrict these items. And you recently just saw that the 10th Circuit issued a ruling in their favor. This is not good news, but this case is far from over, and there's a lot still to develop in these challenges. Now, the facts surrounding this case are that Mr. Tamori Morgan was charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. section 922-0. Specifically, the individual here, Mr. Morgan, was charged with possessing an AM-15 machine gun and then also a machine gun conversion device, which was simply a Glock switch. It is the possession of those 2 items that got him charged and convicted, but he moved to actually remove and dismiss the possession convictions. He claimed that under the Second Amendment that those were unconstitutional, and therefore those convictions should be dismissed based on what the Supreme Court recently said in cases like Bruin. On review, the district court found and ruled in his favor. The judge there stated that defendant argues that 18 U.S.C. section 922-0 is unconstitutional facially and as applied to him. Defendant first argues that under the first step of Bruin, the plain text of the Second Amendment applies to his conduct of possessing machine guns. The government argues to the contrary, pointing to language in Heller that suggests the unconstitutionality of machine gun regulation would be startling and that the Second Amendment only applies to weapons that were commonly used by law-abiding citizens at the time of the Second Amendment's enactment. When looking at the Supreme Court's precedent in Heller, the court there found that the government relies on Heller to argue that machine guns are not covered by the plain text of the amendment. The Heller language cited by the government is unavailing. First, the government's interpretation of Heller relies exclusively on dicta. Machine guns, however, he states, were not at issue in Heller. Second, the government's interpretation would run directly counter to the essential analysis in Heller. Just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. So the court there rejected the federal government's arguments that Heller supports these type of machine gun restrictions, and he ruled against the federal government. The judge stated that suffice it to say that the weapons at issue in this case are bearable arms that under Bruin's first step are covered by the plain text of the Second Amendment. The judge then reviewed all the federal government's historical analogs, and he tried to see if there was any history or tradition to justify the GCA's restrictions, but the court found that the government did not meet that burden. Now, it's important to note that the judge here stated expressly that the federal government really only put forward 2 analogs to support this type of restriction, probably because the federal government, the Biden DOJ at that time, believed that they wouldn't even get past the first step, that the court here would just find that they are not protected arms, so they would not have to put forward historical justifications. However, this did get past that first step. And so since the federal government didn't really put forward any history or tradition to support this restriction, the judge here ruled against them. After losing at the district court level, the federal government then appealed to the 10th Circuit, asking for the court there to reverse that lower court ruling. So despite the new Trump, Second Amendment executive order and the new 2A task force, and AG Bondi and the whole administration say that they're going to take pro-2A stances, they continue to argue in this case and another case, the Brown case in the 5th Circuit, that machine guns can be restricted despite the Second Amendment. Now, during oral arguments, the Trump DOJ and the attorney there relied heavily on Heller and the dicta there, and they tried to use that as a basis for banning machine guns. The U.S. attorney conceded that machine guns are arms and that they should be protected, but they also stated that, these were dangerous and unusual items, therefore they could place restrictions on them. Well, we just received the ruling out of the 10th Circuit after those oral arguments, and it's not good. The court held that Morgan failed at the very first step of the Supreme Court's Bruin test, essentially that, proving that the machine guns he possessed were arms in common use today for lawful self-defense. They claimed that he did not meet that burden. The judges emphasized that although handguns and other widely owned firearms are protected, machine guns like Mr. Morgan had, the AIM-15 and the Glock switch, they said are not commonly used for lawful purposes by law-abiding individuals for purposes like self-defense. Instead, they argued that history and precedent show that these items, that these machine guns, are overwhelmingly used and linked to unlawful uses. They're not used for civilian defense, and they claim that they're primarily just used in crimes. Again, I don't agree with that, but that is what the 10th Circuit found. The court there leaned heavily on Heller's dicta, stating that weapons most useful in military service, like the M16 rifles and machine guns, may be banned under the Second Amendment. It also pointed to historical patterns, and they stated that Congress and states have consistently restricted machine guns since the 1930s because of their association with criminal activity, and they claim that they remain, highly regulated today, and they're highly used by criminals, and therefore they could be restricted. The court there found that because Mr. Morgan could not show common lawful use for self-defense, the court had to conclude that his constitutional challenge failed. The indictment against him was reinstated, and the case after that opinion was argued to be sent back down to the district court for a new proceeding. So that's not good news, but this case, like I said, is far from over. Mr. Morgan and his attorneys will likely now seek en banc panel review in the 10th Circuit, so this will now simply move one step forward and likely one step closer to Supreme Court review. There is also now a strong likelihood that the 5th Circuit, reviewing the other machine gun ban case that relied on Morgan, that case is Brown versus the United States. It's likely that the 5th Circuit will take notice of this new ruling and maybe rule the same way. The 5th Circuit still has yet to set oral arguments in that case, but there is no doubt that the ruling will be brought up, when those oral arguments happen. But again, keep in mind the 5th Circuit does not have to follow what the 10th Circuit said, and the 5th Circuit has been fairly pro-2A, but when it comes to these, side issues or these controversial or quote-unquote controversial issues like the GCA or the NFA, the 5th Circuit has not been super friendly, so it's going to be interesting to see how this new decision in Morgan impacts what happens in the 5th Circuit. My hope now is that some organizations, some 2A orgs, will jump in to help Mr. Morgan on his appeal to the en banc panel, similar to what we saw happen when the Peterson suppressor case got elevated to the 5th Circuit en banc panel. My hope is that you have 2A orgs step up and help Mr. Morgan during that appeals process. But for now, there has been a temporary setback on this whole machine gun challenge issue. But like I said, this is far from over, and now this will simply get elevated to the next level. Now we're going to be waiting to see, how does the 10th Circuit handle this? Do they take this en banc? And then also, what impact will this have on the case that's currently pending in the 5th Circuit? So that's what just happened in the critical machine gun, ban challenges that were moving their way through the process. That decision in the lower court, which was very good, which was pro-2A, has now been reversed by the 10th Circuit, and we're going to see how that impacts all these other challenges going forward. So as we get more information, As it develops, I will let you guys know. If you would like to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also make sure YouTube is not unsubscribed you because they do that quite often. And also you can check out my website, ARMEDSCHOLAR.com. Over there we have a lot for you guys, like deals, coupons, channel merch, other things. And then also the free legal guide that you can sign up for. All you have to do is put in your email. We email you over a PDF, and then we do some follow-up emails as well with free educational information, some daily deals, and things like that. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.